Well, good evening and welcome to you all, and welcome to the Branigin lecture. My name is Branigin, and I'm the director of the Institute for Advanced Study. And the Institute sponsors a variety of collaborative research-oriented projects on campus throughout the year. We have distinguished fellows who come for 2 to 3 weeks and do research with other faculty members at IU. We also have distinguished citizens who come for usually shorter periods of time and who are distinguished in their careers as businessmen or businesswomen or judges or people in political life. And we also have Branigin lectures, a very special category indeed, in which we are able to bring to the Bloomington campus various scholars, thinkers, distinguished citizens who are provocative thinkers, who are engaged in dealing with and thinking about the issues of our day in very useful ways. The Branigin lecture is supported by an endowment from the estate of an IU Bloomington alumna, Jean Lois Porteous Branigin, and this series brings Branigin lectures to campus several times during the course of the year. And during their stay, the lecturers not only give a public lecture, but meet informally with faculty, with students. They make themselves available, and as our Branigin lecturer this evening, they're very generous with their time, for which we are very grateful. And we're delighted and honored to have with us as our lecturer this evening the Honorable Michael B. Kirby of the High Court of Australia. Justice Kirby has served on the High Court since 1996, and he's been a judge since 1975, serving on the Federal Court of Australia and as president of the Courts of Appeal of New South Wales and the Solomon Islands. In the 1990s, he served as a special representative of the Secretary General of the United Nations for Human Rights in Cambodia and on many other UN bodies. Justice Kirby is currently a member of the International Bioethics Committee of UNESCO, the Ethics Committee of the Human Genome Organization, and the Global Panel on Human Rights of UN-AIDS, the joint United Nations program on HIV/AIDS. This, believe me, barely scratches the surface of his contributions in the many, many ways in which he contributes to society and to jurisprudence. And his topic tonight is terrorism, global response to the courts. It's a great honor and a great pleasure to welcome back Justice Kirby, who was here 4 years ago, giving a talk inaugurating a chair in this law school. So we're honored that he's back with us. He's traversed half the globe to be with us this evening. Please join me in welcoming him very warmly.
Professor Ammon and ladies and gentlemen, it's a great pleasure to be here tonight. I acknowledge Justice Sullivan, who is here from the Indiana Supreme Court, and I'm very pleased to see a number of friends, new and old friends, who've come along tonight. I'm particularly pleased and proud that in the audience is the new director of the Kinsey Institute, Professor Julia Hyman, who is at the back here. I am a member of the board of governors of the Kinsey Institute, and I can tell you, having attended the first meeting of Professor Hyman, that you are very fortunate to have such a wonderful leader for the Kinsey Institute. She's going to give tremendous impetus to what is a real jewel of this university, an undervalued jewel. In global terms, the Kinsey Institute is globally known, globally recognised, and it's going to be even more so after the film, which is coming up. It's going to look all around the world. So anybody who didn't know knowing, and anybody who didn't know Kinsey is going to know of the courage and integrity of Indiana University, of Herman Wells, and of the dedication to scholarship and truth, which should be the guiding star of every university, and is, I believe, of Indiana University. Now, my talk tonight, like Caesar's Gaul, is divided into three parts. The first part is going to be a resume of the century of terrorism, which the last century was. Terrorism is not something new. We've had a lot of terrorism, but it's been around an awful long time. The second part, which I'll have to deal with pretty quickly, is the course of the decisions of the European Court of Human Rights on terrorism. Because for various reasons in Europe they've had to deal with issues of terrorism, and there are a lot of decisions of the European Court on that subject. And the third part is the interesting part of the lecture, which is about the recent decisions in a number of countries, including this country, concerning the response that courts must give to cases involving terrorists or alleged terrorists. And in the course of that, I'll have to mention some of the decisions concerning the Guantanamo Bay case. So they are the three parts of my lecture. And so I'm going to start first with the century of terrorism, as I call it. As you know, the 20th century began with the great attempts of the anarchists, and subsequently communists, to disrupt the settled order. The First World War began with the act of the assassin of Archduke Franz Ferdinand, and soon after that, when the war was in full swing in Ireland, the Easter Rebellion took place, and the Irish instances of terrorism on one side, the fight for liberation, if you view it from the other side, took hold and has continued in one form or another to this very day. During the 30s, the efforts of Mahatma Gandhi and of Muhammad Ali Jinnah in India, the jewel in the British Empire, sought to wrest that mighty subcontinent from the British. And during the 50s, the efforts of people like Gamal Abdel Nasser in Egypt, Boumediene in Algeria, and General Grivas in Cyprus, sought to secure independence of their countries by activities which were called at the time terrorism, and which in many ways used some of the techniques which we see amongst terrorists in the world today. I remember as a youth, the struggle in Cyprus, because some Australian troops took part in that effort, supporting the British, who were then the colonial power. The British had 28,000 troops in Cyprus. There were only approximately 280 EOCA terrorists, but in the end, by reason of their determination and their techniques of terrorist warfare, they deprived the British of the political will to maintain their rule on the island and effectively drove them out. The techniques were the techniques we've become very familiar with, random violence, not too many people killed, but killed in circumstances that attracted a lot of attention in the international news media and became therefore a very publicised and talked about event. That was the essential technique of General Grivas and of the Mau Mau terrorists in Kenya, and of all the other people in Algeria and other parts of the former colonial empires that sought independence, right through to Vietnam and indeed right up to very recent times in South Africa. I was in South Africa recently at the University of Pretoria, and on my visit I went to the new building of the Constitutional Court of South Africa, which is in Braamfontein, which is just near the centre of Johannesburg. And Justice Albie Sachs, who was a member of the ANC in the immediate cabinet of Nelson Mandela, and who lost an arm in a letter bomb which was sent to him, but is now judge of the Constitutional Court of South Africa, showed me how the building is built on the grounds of what used to be a prison. And it's the only prison that at different times was occupied in a cell by Mahatma Gandhi and by Nelson Mandela. They've left just that little block of the prison standing in the grounds of the Constitutional Court of South Africa, just in case anybody forgets. And that is the way in South Africa, Nelson Mandela in the ANC, very largely modelled on the Indian National Congress, led South Africa to independence. Interestingly, as a little footnote, at the time of Mr. Mandela's inauguration, I was the president of the International Commission of Jurists, based in Geneva. And during his treason trial in the 1970s, when Nelson Mandela was tried for treason, the International Commission of Jurists, though the trial went on for more than a year, sent a series of lawyers, Queen's Counsel and others from Australia and England and elsewhere around the world, who sat in the back of the trial and kept their eye on the judge conducting the trial. And at the end of the trial, Nelson Mandela was acquitted of treason, and had he been convicted, he would have been hanged. We would never have heard of Nelson Mandela. But when he was sworn in as president, Nelson Mandela sent a telegram to the International Commission of Jurists and said, would you please send the president of the International Commission of Jurists to my inauguration? So by that chance, I happened to be the president. I was there in Pretoria on the day that the power shifted from the Afrikaner government to Nelson Mandela, and I stood there as the fly-past occurred, and in the sunshine I saw the heads of the military forces with their medals won in battle against that moment, saluting the new state president in a moment against which they'd spent their whole lifetime fighting. So, in some instances, terrorism is a struggle for ideas. Sometimes terrorism has been used in the struggle for independence from colonial rule. Sometimes it's been used in activities of sheer irrationality and cruelty, and it's very important for us all to keep in mind the distinctions. When I was a young boy, aged 11, I heard of the court on which I now sit for the first time. The court, the High Court of Australia, is the Supreme Court in Australia. It is actually the fourth longest serving national final court of appeal. United States Supreme Court, Supreme Court of Canada, the Federal Supreme Court of Switzerland, and the High Court of Australia. And for a relatively young country, it's therefore pretty long established. But the first time I heard about it was in 1951, because a few years before that, my grandmother had remarried, and she married a communist. And he had been a soldier in the Anzac Corps in the First World War at Gallipoli, and then later on the Somme. He was decorated by King George V at Buckingham Palace as a very brave soldier. And he went back, not to New Zealand, where he came from, but to Australia. And he became very disillusioned. And he threw away his medals and he became a communist. And I remember meeting him. For me, he was just my Uncle Jack, a new member of the family. And I have to tell you, ladies and gentlemen, a finer, human being and a more principled and honourable and idealistic person I've never met in my life. I now look back on that time, looking at the books he had. He had the collected speeches of B.I. Lenin. I have to tell you that they didn't look as though they were well thumbed. They didn't appear to have been taken down from the shelf and read many times, but he had all of them there. And there was a journal called Soviet Union. It didn't quite have Technicolor expertise. The colour was a bit rotten, but it had pictures of the workers and peasants in the Soviet Union who were all very happy with their lot. And I would read these things and talk with my Uncle Jack, and I got to know him as a human being and a very idealistic and good man. But then, at about the time that the Smith Act was enacted in the Congress of the United States, the Australian Parliament, under a new government, the Menzies government, decided that it would ban the Communist Party. And so a bill was passed called the Communist Party Dissolution Act, which dissolved the Communist Party, imposed various civil penalties on communists or people who were associated with the party, and threatened a whole complicated series of actions which would involve raiding people's homes, getting membership of the party, isolating the communists, banning them from various forms of employment, and in some cases taking away their liberty. The communists, you see, were the terrorists of 1951. And in Australia, the communists were greatly feared and greatly hated. We had a battalion of Australian troops, an increasing number of troops who were fighting in Korea at the time, and the decision in Dennis against the United States, which was a challenge to the validity of the Smith Act under the Constitution of the United States, was handed down by the US Supreme Court just a few weeks before the case came to the High Court of Australia challenging the constitutional validity of the Communist Party Dissolution Act. The US Supreme Court, by a majority of 6-2, one justice must have sat, upheld the validity of the Smith Act. This in a country which had a constitutional guarantee of freedom of expression, speech, and freedom of assembly. It upheld the validity of the Smith Act, and of course it was a great boost to the government lawyers who were arguing the invalidity of the Communist Party Dissolution Act in Australia. We don't have in Australia a formal Bill of Rights. Therefore, we didn't even have the weapon which was used by the lawyers in Dennis in the United States. We didn't have a hook on which to hang the argument that this legislation was unconstitutional. So instead, various other arguments of a legal character were deployed, including the suggestion that Parliament had set itself up effectively as a court to judge all communists, whereas that was the role of the judicial branch and not something which Parliament or the executive could do. Through that and other arguments, the case was put to the High Court of Australia, and eventually the decision came down, and by a majority of 6 justices to 1, because we are 7, not 9, 6 to 1, the court held that the Act was unconstitutional. It came as a tremendous blow to the government at the time, and a tremendous shock and surprise to most lawyers and others, and to a lot of citizens in Australia, because the citizens had elected the government with a clear mandate to ban the communists. The communists were hated and feared. And the result of this was that the government immediately moved to amend the Australian Constitution to include a provision in the Constitution to permit the Federal Parliament to enact again the Communist Party Dissolution Act in order to make that a valid law. In the United States Supreme Court, it's worth reading to you what Justice Douglas said in his dissent in Dennis in the United States. This is what Douglas said. Communists in this country have never made a respectable or serious showing in any election. I would doubt that there is a village, let alone a city or country, or county or state, which the communists could carry. Communism in the world scene is a bogeyman, is no bogeyman. But communism as a political faction or party in this country plainly is. Communism has been so thoroughly exposed in this country that it has been crippled as a political force. Free speech has destroyed it as an effective political party. And effectively that's what the justices of the High Court of Australia said in the Communist Party case. They said the way to fight communism, which is an idea, is to fight it with ideas. If communists do antisocial acts, there's plenty of power for the Parliament to enact laws to allow action to be taken against those who do the antisocial acts. But simply for holding an idea or espousing an idea, that is something that the Parliament cannot touch. And so the Communist Party case in Australia was quite a contrast to the decision of the US Supreme Court, and the more odd because of the lack of the constitutional foundation with which to attack it. And the fact that the judges in the Australian case were judges who had spent most of their life deciding commercial decisions, because the case is a general court of appeal, not just a constitutional court, and wearing horsehair wigs and looking terribly old-fashioned and respectable, staying at clubs and mixing only within the legal profession, yet these judges, with not a great deal of political background or knowledge, came to what I think nowadays would be regarded as the prudent and wise decision, whereas the great Supreme Court of the United States, with the principles of the First Amendment before them, came to a decision on which at least it's open to the view that Justice Douglas got it right and the majority got it wrong. In Europe, during the last 30 years, there have been a series of decisions concerning the extent to which European states can deal with the issue of terrorism. It's come up in three countries, mainly: Ireland, Germany, Italy, and Spain. In Ireland, it's come up in litigation concerning the IRA and the measures that have been adopted both in the Irish Republic and in the United Kingdom to respond to the acts of violence or terror which have been used by the military faction of the IRA. And the cases, when you look at the cases in Europe, I don't have a lot of time to deal with the European cases. Those of you who are particularly interested in them, I've given Professor Eamon a paper, and it's interesting to see how many of the questions that have come up in recent times in the United States cases have been dealt with by that great court, the European Court of Human Rights. Being no doubt that it is a mighty court with a tremendous jurisdiction and tremendous integrity, and it decides cases that affect countries from the Atlantic coast of Ireland to Vladivostok. It has an enormous jurisdiction, and it's stamping on the whole European peoples the principles of the European Convention on Human Rights. In the Irish cases, the decisions have mainly concerned the power of derogation from the obligations under the European Convention. In certain matters, to which there are some exceptions, states can derogate from their obligation. And so in particular times of terror, the Irish Republic and the United Kingdom have made derogations which they deposit in the European Court of Human Rights from their obligations under the Convention. There are some things they can't derogate from. They can't derogate from retrospective laws, that's non-derogable. And they can't derogate from torture and cruel and unusual punishments. And so the questions have often been, in all of the European cases, whether derogations by governments are permissible under the Convention. And many of them have been addressed to the provisions in laws which have derogated from the Convention, permitting the holding of prisoners without access to courts, and sometimes without access to lawyers, which will be permissible under the Convention. Many of the Irish cases bear a marked contrast with the recent United States decisions, because the period of time in the Irish cases of removal from access to lawyer, removal from access to a court, has been a matter of days. Arguments have been made that non-access to courts of 4 days was excessive. And many cases have concerned also telephonic interception of mail and telephone calls, the fairness of the trial process, access to lawyers, as I have mentioned. And an issue that arose in the recent United States case in Rasool and Bush, who bears the onus of establishing that there is a basis, an incorrect basis of holding. Does the person who is alleged to be a terrorist have, in a sense, to prove that they are innocent? Or does the obligation lie on the state that makes the accusation, which would normally be the principal, bear the onus of proving that the person, or not of proving, but of providing sufficient material to establish a genuine and legitimate basis for holding them? So that if you look at the Irish cases, if you look at the German cases concerning the so-called Red Army faction, the Bader-Meinhof Brigade, named in that way after Andreas Bader and Ulrike Meinhof, who were members of the Red Army faction. If you look at their complaints concerning the conditions in which they were kept, complaints concerning their lack of access to lawyers, if you examine the way the European Court looks at them, you realise that in the area of terrorism litigation, there really is nothing very new. It's all been gone over in European cases. The Italian cases are interesting because in Italy, a person who was alleged to be a member of the Red Army, which had been allegedly involved in capturing a former Prime Minister of Italy, Mr. Moro, and murdering him, was put on an island off the coast of Sardinia. This, I should hasten to say, was an island, the sovereignty of which belonged to the Italian Republic. But he was put there in a dilapidated, decaying prison of the kind that you could perhaps visualise one of the more artistic Italian film directors portraying, and no doubt it will be portrayed in due course. And he was held there effectively incommunicado in this circumstance. He was subsequently acquitted of terrorism by the civil courts, and he then proceeded to the European Court of Human Rights and complained about the condition in which he had been kept. Between the time of his complaint and the time of the hearing by the European courts, under the Italian procedure, the acquittal was reversed and he was convicted. He was sent back into a proper prison in Italy to be kept there on a terrorism offence. Notwithstanding that, the European Court of Human Rights held that the conditions in which he had been kept on this island off the coast of Sardinia was primitive, barbarous and contrary to the requirements of the European Convention on Human Rights. It found Italy was in breach of the Convention. It made declarations which effectively required Italy to ensure that no similar action was taken against an alleged terrorist, and it ordered compensation to him. I don't know whether that was of much comfort to him sitting in his cell, but it upheld the principle concerning the conditions in which terrorists, people alleged to be terrorists, guilty of terrorist crimes, are to be kept. The Spanish cases are interesting because they involve the Catalan army and the ETA, the Basque country group. The Basque group, ETA, has been guilty, it is alleged, of some 600 murders in the past 20 years. And there is a case pending in the European Court of Human Rights at the moment concerning a decision of the Spanish Parliament, upheld by the Spanish courts, that the political wing of ETA has no right to stand in the elections in Spain. The European Court has very strong line of authority on this, mainly to do with challenges by the Communist Party in Turkey concerning the fundamental right of people to organise themselves politically and to get involved in the political process. So it will be interesting to see what the European Court does following the terrorist incident in Madrid and the line of authority which has been decided in the cases concerning Turkey. So this gives you a bit of a taste of the fact that in Europe there's 25 or 30 years of established decisions of a very serious court with rights of dissent, majority and minority decisions, well-reasoned, well-argued, grounded in the principles of the European Convention on Human Rights. There's plenty of law on this subject. And if you look at the issues that have come up in the United States and other terrorist cases, you will see many similar things. And it's therefore important for lawyers and political scientists to realise we're not dealing with an unploughed field in this matter. This is well-ploughed legal territory. I now come to the third part of my lecture, which is designed to give you a number of recent cases concerning terrorism in a number of countries, one only of which is the United States of America. In the year 2001, but before the events of the 11th of September, the South African Constitutional Court, you remember I told you about this court, which has been set up under the new constitution of South Africa, had a rather unusual case. It concerned a man whose name was Mohammed, and he was an alien in South Africa. He was not a citizen of South Africa. He entered South Africa, and at that stage a warrant had been issued for his arrest by a United States District Court, alleging that he was involved in the bomb attempt on the United States Embassy of Dar es Salaam. You may remember that. And that warrant was out, and this man was taken into custody in South Africa, and as an alien, the Immigration Service of South Africa said, you have no right to be in this country, we're going to deport you, you must elect whether you want to go to the United States of America or to Tanzania, there to face trial. He said, I don't want to go to either of those countries. I am going to assert my rights under the South African Constitution. So he commenced the proceeding in the High Court in Cape Town, and the judge of the High Court in Cape Town refused him relief. He then sought constitutional relief in the Constitutional Court of South Africa. He went up there. Meantime, the officials of South Africa simply put him on a plane and sent him to the United States. He was there seized, and he was put on trial in the US District Court in New York. So the case was called over in the Constitutional Court of South Africa. And I can tell you as a judge of long experience that there would have been plenty of reasons that the Constitutional Court of South Africa could have given, quite legitimately, to say, we're not going to get involved in this case. They could have said, well, the matter is now moot. The man has passed out of our jurisdiction. Maybe he shouldn't have been, but it's not under our physical control. He's gone, and we can't effectively do anything we're not going to make any orders because courts don't do futile things. But remember that the Constitutional Court of South Africa is administering a new constitution, and they've been perfectly accustomed, all of them, with state laws. And it's pretty clear from the reasons of the court in Mohammed against the the President of the Republic of South Africa, that they were rather upset by the decision of the officials to send this man to one of two countries, in both of which he could be executed, because it's a fundamental principle of the South African Constitution, upheld by the Constitutional Court, that you cannot administer capital punishment in South Africa. And accordingly, the Constitutional Court took the case on. And in the course of their reasons, they referred to a famous passage in the decision of Justice Brandeis in Olmsted's case, when Justice Brandeis had said in Olmsted of the United States in 1928, "In a government of laws, the existence of the government will be imperiled if it fails to observe the law scrupulously. Government is the potent, omnipresent teacher. For good or ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy." Wonderful words, Justice Brandeis, 1928. And in their decision, in the Constitutional Court of South Africa, in which they held that the case was pending before them, that a person had properly invoked their jurisdiction, that his constitutional rights in South Africa had been denied, that they had been denied by officials of the state of South Africa, and therefore he was entitled to a declaration that his rights had been abused, that the proper category of law to apply was not deportation but extradition, and in extradition it is not at all uncommon for a state which doesn't believe in capital punishment to require an assurance that the state receiving the prisoner will not inflict capital punishment on the prisoner. And so this is what the Supreme Court of South Africa, or the Constitutional Court, said. "We saw in the past what happens when the state bends the law to its own ends, and now in the new era of constitutionality we may be tempted to use questionable measures in the war against crime. The lesson becomes particularly important when dealing with those who aim to destroy the system of government through law by means of organised violence. The legitimacy of the constitutional order is undermined rather than reinforced when the state itself acts unlawfully." And so they issued their declaration, and they directed that the registrar of their court send their decision to the judge who was conducting the trial in the US District Court of Mr. Muhammad. And so he did. And whether it was for that reason, or whether it was because of the verdict of the jury, or whether it was for some other reason, the net result was that Mr. Muhammad was convicted, but he was not sentenced to death. As far as I know, as we sit here, he's in a prison cell serving his sentence imposed upon him by a United States District Court. My second illustration is a case in England. In England, this case was decided in March of this year. The case concerned a Libyan national who had come to England, and under England's new terrorism law, which was enacted in 2001, after the events in September of that year, the Home Secretary of the United Kingdom has the power to issue a certificate requiring that a suspected terrorist be taken into custody, held there pending Her Majesty's pleasure. And so the British have set up a system whereby persons who are the subject of such an order can challenge them immediately in what's called the Terrorism Appeals Commission. The commission must be headed by a judge or former judge, and it has two other members, and the commission can decide whether or not the Home Secretary's decision is reasonable. But under the British legislation, an unusual provision is included, which I've never seen anywhere else, which provides for the office of the Special Advocate. And the Special Advocate, under the Act, is a person, normally a Queen's Counsel, who is given access to most, though not necessarily all, of the material in the possession of the government. And that information is not passed on to the accused, but it is the job of the Special Advocate in the hearings of the tribunal, within the material that is provided to him or her, to represent the accused terrorist as best they can. And to the utter astonishment of Mr. Blunkett, who is the Home Secretary of the United Kingdom, I don't know if you've ever seen him on television, he's a man who is blind. He is a very able minister, but shall we say a very determined minister. He's like the English equivalent of Mr. Rumsfeld. He doesn't hesitate to attack Her Majesty's judges, and indeed he's got to the point that now it's pretty clear he rather enjoys doing it. And this is something entirely new in Britain, and they've not yet become entirely used to it. However, they found in the Commission, with the assistance of the Special Advocate, that the decision of the Minister was unreasonable on the material. Ironically enough, Mr. M, who was the accused, refused to have anything to do with the Special Advocate. He had absolutely no confidence in British justice or their tribunal or this peculiar beast that they had created to the point of defending his interests. No doubt he watched in Libya a number of episodes of Yes Minister. He thought that this was simply one of those whitewashing techniques that the British are really particularly skilled at inventing, which would give the appearance of justice but no substance. But as it turned out, the Special Advocate, who was a QC and who appeared later to uphold the decision of the court, of the Special Appeals Tribunal, did a good job, and the Commission held that the Minister's decision was unreasonable. Mr. Blunkett, needless to say, was apoplectic at this decision and challenged the decision in the Court of Appeal in England. And so the case went to the Court of Appeal, and they describe at some length, and I put it in my paper, the legislative scheme for the Special Advocate, because it's an unusual thing to have somebody who's representing an interest but doesn't have access to all of the material, but has access to some material that the person who he is representing is not himself or herself entitled to get. But anyway, this is what Lord Chief Justice Lord Wolfe had to say. Having read the transcripts, we are impressed by the openness and fairness with which the issues in closed session were dealt with. We feel the case has additional importance because it does clearly demonstrate that while the procedures which the Commission have to adopt are not ideal, it is possible, by using special advocates, to ensure that those detained can achieve justice, and it is wrong, therefore, to undervalue the appeal process. While the need for society to protect itself against acts of terrorism today is self-evident, it remains of the greatest importance that in a society which upholds the rule of law, if a person is detained, as M was detained, that individual should have access to an independent tribunal or court immediately, which can adjudicate upon whether or not the detention is lawful. If it is not lawful, then he has to be released. And Mr. M was released. And there are pictures in all the newspapers of Mr. Blunkett looking extremely discomforted and upset, and Mr. M being released in the city of Leeds, where, as far as I know, he's continuing to live a placid life. The third case I want to mention is a case in May. So we've got March, May. This is a case of the Supreme Court of Israel. Normally I come to the United States at this time of the year for a conference at Yale Law School, and President Barak of the Supreme Court of Israel is always there and tells us of the cases in Israel that year. The case in Israel this year, in May, was the case of the so-called security fence in war. You know that Israel has built a security fence around it for the purpose of preventing the terrorists getting into Israel and blowing up bombs and killing large numbers of people. And no doubt that since the wall has been built, the number of such attacks or successful attacks has reduced very significantly. And so a case was brought in the court by the village council of the Palestinian village of Beit Surit. And the Palestinian council went to the Supreme Court of Israel to challenge the building of the wall on the land of this village in Palestine. Now, once again, ladies and gentlemen, you can understand, particularly if you think of wartime cases, it would not be difficult for a judge in such a case to say, non-justice, this is a political question. We're not going to get involved in this matter. This is a matter for the executive, this is a matter for deference. We don't have the expertise, this is military, and the defence of the nation is at stake. But not the Supreme Court of Israel, because the Supreme Court of Israel said the question of the building of the wall is not a judicial question. That is a matter for the defence forces of Israel. But once they decide to build the wall, the trajectory of the wall and where they put it is the use of power of an organ of the state which is reviewable in the courts. And we find that in the trajectory of the wall, the way in which it's been built, it intrudes excessively in this area and unnecessarily and unreasonably into the Palestinian lands. So the Supreme Court of Israel, in the midst of what is seen in many parts of Israel as a struggle of life and death, upheld the challenge of the village of council of Site Haray. And Justice Barak, in his reasons, said this. Listen to these words. Our task is difficult. We are members of Israeli society. Although we sometimes live in an ivory tower, that tower is in the heart of Jerusalem, which is not infrequently hit by ruthless terror. We are aware of the killing and destruction wrought by the terror against the state and its citizens. As any other Israelis, we too recognise the need to defend the country and its citizens against the wounds inflicted by terror. We are aware that in the short term, this judgment will not make the state's struggles against those rising up against it easier. But we are judges. When we sit in judgment, we are subject to judgment. We act according to our best conscience and understanding of the law. Regarding the state's struggle against the terror that rises up against it, we are convinced that at the end of the day, a struggle according to the law will strengthen her power and her spirit. There is no security without law. Satisfying the provisions of the law is an aspect of national security. And he quoted what he had said in an earlier case and then concluded, only a separation fence built on a base of law will guarantee security to the state and its citizens. Only a separation route based on the path of law will lead the state to the security which is so yearned for. Supreme Court of Israel, May 2004. I want to mention a decision which was close to my country, made by the Constitutional Court of Indonesia on the 24th of July 2004. This was a decision concerning a prisoner who had been convicted of involvement in the Bali bomb. You may remember this was a bombing that killed 202 people in Bali in a nightclub, including 88 Australians. As our population is about a tenth of yours, to get an idea of its equivalent impact, it's killing about 880 Americans. So it's a lot of deaths for Australia, and it therefore captured a lot of attention. The case brought by this person to the Constitutional Court of Indonesia was not unpredicted. It was constantly talked about in the Australian media, print and electronic, during the trial, because the accused was charged not for the offences of conspiracy or murder or involvement in explosives. He was charged, as were the other Bali defendants, with a terrorism law which was rushed into operation within days after the Bali bombing. And the only problem with that provision was that there was an express provision in the Indonesian new constitution forbidding retrospective criminal laws. And therefore the question that was raised in Australia was, why have they charged them with this new offence when they will then have to run the gauntlet of the law against retrospective punishment, which is pretty fundamental and is in most of the human rights documents. I think it's in your constitution. It certainly is in the European Convention on Human Rights, and it's in the Indonesian constitution. And so the case went to the Supreme Court of Indonesia, and that court, by a decision of 4-3, upheld the challenge, set aside the conviction. And now a question is presented as to whether the person can be retried on an offence which was different in terms but similar in substance. And therefore the Indonesians have got themselves into a bit of a mess over this matter. The Sydney Morning Herald, in what I thought was a more than usually enlightened, we have presented Fox and News Limited to you in the United States, and we're very glad that you have this gift from Australia, and we hope that you appreciate it. I saw a very nasty little comment outside in this university today about Fox News, but I won't go there. Anyway, the Sydney Morning Herald said, the Indonesian Constitutional Court's decision should be seen for what it is, part of a proper legal process in which every person has the right to exhaust all avenues on appeal. This is a positive development for Indonesia. The ensuing legal uncertainty and inevitable stress it will cause could and should have been avoided. Now, the only other set of cases to be talked about are the decisions of the United States Supreme Court in the terrorism cases. The decision was made in July of this year. Those cases are Hamdi and Adila and Rasul. Hamdi and Adila were two American citizens who challenged the way they had been dealt with. Adila went off on a technical problem concerning the availability of habeas corpus to Mr. Padilla. But in the course of his reasons in that case, which informed the approach that he took in the opinion that he wrote to the court in Rasul and Bush, Justice Stevens of the Supreme Court of the United States said this: at stake in this case is nothing less than the essence of a free society. Even more important than the method of selecting the people's rulers and their successors is the character of the constraints imposed on the executive by the rule of law. Unrestrained executive detention for the purpose of investigating and preventing subversive activity is the hallmark of the Star Chamber. For if this nation is to remain true to its ideals symbolised by its flag, it must not wield the tools of tyrants, even to resist an assault from the forces of tyranny. Justice Stevens in Padilla. And essentially, in the decision in Rasul and Bush, that was the view that was taken. In this country, ultimately, people, including aliens, including non-citizens, will be able to invoke the protection of due process, because the due process clause in the United States Constitution is not addressed to citizenship. It says no person shall, and is therefore addressed to human beings, and it's not limited to citizens. And the working out of the due process formula in the United States, in particular having regard to what Justice O'Connor said in one of the decisions, which on one reading tends to lower what is expected in the case of persons who are accused of terrorism offences, and in particular of aliens, is something that still has to be decided in the courts of this country. In an article soon after the trilogy of decisions in the Supreme Court, Ronald Walker wrote in words that I think probably would find reflection in the views of lawyers all over the world, and especially if they're familiar with this territory of terrorism decisions. This is what Professor Dawkins said. The world is shocked by our willingness to abandon what we claim to be our most fundamental values, such as due process, just because our victims are foreigners. We must hope that Camp X-Ray and Abu Ghraib soon become symbols of a national aberration, like the American Japanese internment camps of World War II, that we must take care not to repeat, rather than evidence of what, to our shame, we have now become. It's not for me as a foreign judge to say what I think about the American decisions. My purpose tonight is to bring to your attention the fact that those decisions don't stand on their own. One of the great lessons of a judge of a final court in today's age is we are not alone. We are dealing all the time with problems which are very similar in different countries. They're coming at about the same time in all of our courts. That's what we talk about at Yale, how astonishing it is that the same problems are coming all the time. And clearly, the terrorism issue is going to be here for some time. And it's therefore very useful, I think, for judges of final courts and for all lawyers and all judges to keep an eye, not just on what happens at home, but to keep an eye on the fact that these are global issues and there are courts in many lands which are dealing with them. And essentially the lesson that I draw from my Uncle Jack and the Communist Party case in Australia 55 years ago is business as usual. Courts must do business as usual. There must be no exceptionalism. Terrorism cases are simply other cases. They must be dealt with applying the rule of law. And we can now enhance our understanding of the application of the rule of law, making all due allowance for the differences of our constitutional provisions, differences of our constitutional tradition, taking on board the wisdom and experience of judges, lawyers in other lands who are dealing with exactly the same problem at the same time. So that's what I came to say, and you can now give a big round of applause. Branigin lectures. This is not a speech from the throne. You can say what you like, you can criticise, you can comment, and you can ask questions. So are there any questions or comments? Or criticism? Yes.
I'm not a lawyer, I'm a scientist. The judicial system is not without its own trade-offs. And the concern I have with the argument you're making stems from my somewhat cynical view of the legal system, in that, think of the Indonesia case you cited, but for a technicality, he would have been found guilty of a gross crime, but because someone made a very stupid decision early on in the piece, it opened it up to that opportunity. And I've seen time and again situations where that has occurred. And the reason why I raise this is the nobility of your views you're taking presuppose that there aren't these practices, so that there can't be miscarriages of justice, and they do occur. How do you respond to that?
Well, I spend all my life dealing with miscarriages of justice. I'm therefore very familiar with miscarriages of justice. Cases don't get to my court. In most instances, the people feel that they will say there's been a miscarriage of justice. So miscarriage of justice is no stranger to me or the courts. And we spend a lot of our time seeking to change mistakes and correct them. But it's not a technicality to charge a person under a law with retrospective operation. If it were just a technicality, you would have to ask yourself, why do so many constitutions and universal human rights instruments say that you can't do it? And the reason you can't do it is because those who have power or seize power can, under retrospective laws, simply reshape the law and say it applies to past acts, and we're therefore going to hold you liable by our standards, not by the standards which applied at the time. It has been and I think properly is, a serious derogation from the rule of law, because you're then not holding people to a legal standard that applies, you're holding them to some legal standard which has been imposed by power retrospectively. There, from ancient times, there's been a strong presumption of the English law shared in this country and in Australia that you do not presume that that can be done, and in some cases it will be unconstitutional if it is done. It's happening more often than it used to happen. We have a case that is pending in our court concerning a person who has served a full offence, a very long prison term, for a sex offence. And because of the excitement in the media of pending release of the person, the legislature has enacted a law which effectively says that the person can be held after finishing the offence and detained in the same prison, the same cell, subsequently, although the prison sentence for the offence has been completed. That has been challenged in my court as being another intrusion by Parliament into a function that belongs to the judiciary. So that this can sometimes happen for political reasons. But the job of courts, and particularly people like me, is to make sure that legislators and executive government stick to the rules.
I didn't question the decision of the court.
Well, it's not a technicality.
No, what I
It's a
was...
serious breach of fundamental rule.
The point I was making was not that the court made the correct decision. I wasn't arguing that. What I was saying was the wrong charge was made in the first place. Had he been charged with murder, he would have been found guilty.
This was not one of the bomb planters. This was somebody who I think purchased a truck. And most of the bomb planters didn't appeal and take this point. So the question now will be, will they be executed? And there's a new president, as from today in Indonesia. Will they be executed on a law which the Constitutional Court has held to be unconstitutional, even though they haven't appealed? It's a very messy business. All of this was repeatedly called to attention by legal experts in Australia at the time. But it was sexy to charge a person, if I can be forgiven, a Kingsley Institute, to charge a person with a terrorism offence. They rushed it through, charged them with that offence. This was not unheralded. This was an issue which was drawn to notice. That is what happened. And it does show, again, if I can suggest it to you, how important it is in the matter of confronting and dealing with terrorism to keep to the rules, not to, as it were, invent new rules and retrospectively apply them, or to have absolutely different rules, or to say rules don't apply. Very important, I think. The lesson of history, the lesson of the cases, the lesson of the work of the European Court of Human Rights, with tremendous experience over 30 years in this field, is stick to the rules, have a standard, have a principle. Even in terrorism, bring government back to answer to the rule of law. That's what constitutionalism is about. And that, strangely enough, is what the judges with the horsehair witnessed in Australia in the case of the Communist Party case, and what was not done in the Supreme Court of the United States in Davis. Just got to keep calm and apply the rule of law at all times for everyone. That's the business, that's the job. Any other questions? Now there must be a question from the American audience. Yes, Professor. Thank you very much.
You talked about a number of cases from different countries dealing with somewhat similar issues. To what extent do courts of some countries look to courts of other countries and look to their decisions and to their jurisprudence and use the reasoning, the analogies and whatnot in their very own decisions? And what do you think of, I believe it's Justice Scalia's view that this is not something that courts should do?
Well, in the Commonwealth of Nations, in the British Commonwealth, we've always looked to each other because from the very beginning we looked to the British courts and in the early days were subject to the British courts. And therefore the habit of mind of looking outside ourselves to a great world legal system goes on in Australia, in India, in Malaysia, in Singapore, in Canada, New Zealand, all around the Commonwealth. We're constantly looking to other Commonwealth courts. They write in English, their techniques are the same, law is rather similar, and therefore we do it. In the earliest days of my court, we also added the Supreme Court of the United States because our constitution is very similar to the United States. And therefore, in doctrines of separation of powers, the judicial branch and so on, we're constantly looking at United States, especially Supreme Court decisions. And that's increased, if anything, in recent times. So I'm very familiar with the debate of Justice Scalia and of Justice Kennedy in Lawrence and Texas. We've had similar debates in Australia. In the United States, at least in recent times, there has been less inclination to look outside. And I think that's historically understandable and geographically understandable because you have 50 plus jurisdictions. You've got a hell of a big job just keeping up with each other. But it's often useful to look outside your own jurisdiction because it gives you a corrective against living in a cocoon where you just follow everybody, and it can sometimes be a case of the blind leading the blind. So that I don't agree with Justice Scalia, and I'm sure that Justice Scalia has lost the argument because you cannot say, if you read those European decisions, if any of you are interested, get my paper, look at the footnotes, just glance at them. All of the questions in Russell and Bush were dealt with 10, 15, 20 years before by the European Court of Human Rights. Is the onus on the prisoner or on the state? Is the state answerable? Can it keep a person for 6 days, 10 days, for 3 months was the case in Spain? The European Court said no. Without access to lawyers, no. You've got to give access to lawyers. You may restrict what the lawyer will do. You may set up something like the British have set up, but you can't deny people access to lawyers. The German cases are about keeping people incommunicado. Can you deprive people of sensory stimulation, as was alleged in the Branigin cases? No, you can't do that. So there's a whole bevy of law in Europe on these subjects. And we should be intellectually big enough and honest enough where it is helpful, making all allowances for the difference, to see how other countries have dealt with issues. Both you and we in Australia look to very wise old English judges in the time before your revolution, the time before our federation, and even more recently, for dealing with general principles. But now there are other people and other courts that deal with general principles. And it's therefore often very useful for your analysis to look to what they have said on these general principles. There's nothing lawyers like better than having somebody who's looked at the problem before. We call it the doctrine of precedent. We just love it. We love to have somebody who's thought it all through. We're also busy. We don't always have the time to think it all through. And therefore, if you've got very clever people who've dealt with issues before, it's actually quite helpful. And judges are now doing this. Justice Stephen Breyer comes to the Yale Seminar, and he's very vigorous and he knows all these things that are going on. And Justice Ginsburg was at a conference of Commonwealth judges in Bangalore in 1988, which propounded this view that we should look to international human rights law, not to bind us, but as a general background and principle. And it isn't entirely accidental, I think, that if you look at a decision like Lawrence in Texas or Atkins in Virginia, that these are the judges who are familiarising themselves. Justice O'Connor is the president of SEAL, which is the legal organisation, an offshoot of the American Bar Association, that is helping the Central and Eastern European countries to build a legal system. If you look outside yourself, you realise how so many issues are common. And it really is helpful. And it's beginning to happen, as Lawrence and Atkins show, that it'll happen a lot. It's a new development, and it will affect the law students that are studying law today. And it's a good development, because we live in the one world. It's not just an economic zone, it's a zone of ideas, and of ideas of freedom, and of ideas of human rights and human dignity. It's global. It's largely an American creation. Yes.
Most of the examples you quoted were taken from the English-speaking world. I am wondering whether you could say a few words about issues of this sort that come up in the formerly communist-dominated and now struggling democratic countries such as the Czech Republic, Hungary, Poland, etc., perhaps even to some extent Russia. What is the situation there, and are there any legal comments to be made in those areas?
Well, it's true that the countries I mentioned were largely common law countries. Israel is a partial common law country. The reasons I read from President Barak were, of course, first written in Hebrew and are translated, and they're on the web. Have a look at that case. It's an amazing decision, if you think about it, of the Supreme Court of Israel. And so it's not true that the cases I've mentioned are only from the English-speaking countries. Germany, Italy, Spain, in the European system, were all countries with big terrorism problems. And still in Spain they have it. So far as the countries of Central and Eastern Europe are concerned, most, if not all of them, are now members of the Council of Europe. They are members of the European Convention on Human Rights. They are subject to the jurisdiction of the European Court of Human Rights. The European Court of Human Rights has countless cases, which I refer to in my paper, which lay down the principles. Every one of those countries, in their response to terrorism, will have to conform to the jurisprudence of the European Court of Human Rights. Russia will have to conform to it. You read in the paper two days ago that President Putin has announced that following the terrible event in Dresden, he's going to introduce a new terrorism law, but just for good measure, he's immediately moving to abolish elected governors, and all governors in the Russian Federation are now going to be appointed by President Putin. And that is something you have to keep your eye on, as the Under Secretary of State of the United States said. The misuse of terrorism as a cloak for dealing with all sorts of other agendas. Very important. You don't think this only happens in Russia. It can happen in other countries as well. And it's therefore important for citizens and courts to keep their eye on the long haul. For me, I had a very personal experience of that as a boy of 11. Keep your eye on the long haul. Keep your eye on the fundamentals, and not to get diverted by the excitements of the moment. Politics tends to be a very excitable profession. People in it tend to get very excited. Judges have to take an aspirin and keep calm. Keep your eye on the prize.
Thank you.
There's a question up the back there.
Actually, my question was very for Brandon. Thanks.
Any other questions? Yes, one more.
Are there any guidelines you think that judges should follow in which they would look at an action of the legislature or the executive and say, this is a political question?
Well, I've done that myself in cases. We had a case where an Aboriginal Australian brought a claim seeking a declaration that Australia had to vote in a particular way on a genocide question in the United Nations. And I struck out the summons. I said that was a purely a political question, that under the structure of our Constitution, that belonged to the executive government, exercising the external affairs power of the Constitution, not to the judiciary. So there are cases. There's a lot of debate about the so-called justiciability issue. And it's probably fair and truthful and candidly to say that there are a lot of fudgy edges on it. It's not true to say that judges of courts never deal with political questions. And that would not be a good standard. I'm dealing with political questions every day. In my court, And in other courts dealing with federal or state constitutions, you're dealing with political questions. You can't get away from it. And if you said, well, I'm just not going to deal with that because it's a political question, you would not be doing your job. But it's true that there are some matters, like the case, I believe, that I mentioned, but there are other cases in Australia and doubtless in the United States where it is a purely political question according to the convention, the structure of the Constitution, its language, the case law that is built up around it, and the decisions. But I think many foreigners have been surprised at the extent of deference that has been extended in the United States to the President as Commander-in-Chief. The Governor-General in Australia, who is the representative of the Queen, under our Constitution, is designated the Commander-in-Chief of the Australian Forces. But there would be no way that that would be given to the Governor-General, who appears in Chapter 2 of the Constitution in the Executive, any extra or special status or standing. Now, it's true to say that Australia doesn't deploy the huge forces of the United States or the nuclear armament of the United States, but the principle of giving the President special status, and some of that was argued out in the Guantanamo Bay cases, is one which is surprising to many foreign people looking at it. I often think that the Constitution of the United States was the attempt of the founders of this country to express as best they could the principles of the British Constitution of 1776. And the result of that was the creation of a head of state in the form of the President, elected and removable, but who has the combined powers of the head of government and head of state, which King George III had, which puts enormous power in one person for a period. And what you have to understand is that in constitutional monarchies such as Canada and Australia, the monarchy continued to evolve, and indeed during the reign of Queen Victoria effectively lost all of its powers except to be consulted, to caution and to encourage. But you in a sense are a time capsule frozen in 1776, and that gives you the President the dignity of a head of state, the power of a head of government, and a respect and constitutional status that there's no way that the Queen or the Governor-General or the Prime Minister or anybody else would have in the other systems, because our system continued to evolve, especially in the 90s. So it's the only constitution you've got, and you've got to continue to live with it. But the process of courts, like final courts, is in a sense, I believe, not merely to state what was meant in 1776 or in 1901 in my case, but to see the Constitution as a normative document with a governmental function operating in today's age. And in today's age, the notion of having unaccountable power, unaccountable to the judiciary, is something that's a trifle out of date. And the US Supreme Court essentially said as much. Yes.
After 9/11 in the United States, the U.S. Department of Justice, as part of their campaign against terrorism, they started admittedly selective and pretextual enforcement of immigration and criminal law in certain segments of the society. And the U.S. courts have been largely very acquiescent to that enforcement. I'm just curious if anything similar has occurred either in Australia or in Europe, if you're familiar with their other cases.
Well, in my paper I describe the enactment of a lot of anti-terrorism laws. Australia, you remember, is one of the three coalition partners in the coalition war against Iraq. And Australians have been targeted, and the other day last week or the week before, the Australian embassy in Jakarta was targeted. So that there are anti-terrorism laws in Australia, and we've had many of the same debates as have occurred in the United States. But we do have in our Constitution, in Chapter 3, which is equivalent to your Article 3, a very beneficial provision which was added because of the United States experience. And it permits any person to go straight to the highest court for a constitutional writ of prohibition, mandamus, or writ of injunction. And that gives the court the power to issue it against any officer of the Commonwealth. There could have been no question in the Guantanamo Bay, because it was overseas. If they're taking federal gold, they're answerable in the federal courts in Australia. So that is a provision that gives an immediate access to judicial supervision. But we have many of the same arguments in Australia, the excess and overreach of the statutory and regulatory provisions, and that's a healthy thing in a democracy. We must at once be alert and deal with and take seriously the acts of terrorism in our midst, but we must ensure that we do so in a way that doesn't hand the prize to the terrorists. Because if we downgrade the rule of law and the respect for the principles of the rule of law, then we will really give the gold medal to the terrorists. It's very important we see that. Something similar to this was said in Monday's New York Times editorial. I don't know if you read that. It said that in the past, Americans could look on the Department of Justice to speak up in administrations, whoever they were, and defend basic liberties, and that this was not so now. I don't know enough of whether that is a truthful statement in the United States or not, but it was the opinion of the lead editorial on Monday in the New York Times. All right, well, I think you've all been a very patient audience. We'll have one more large round of applause for us all.